Can unsecured creditors sue after bankruptcy discharge? Have you ever wondered what happens to unsecured creditors after a bankruptcy discharge? This is a common question many people have when navigating the complexities of bankruptcy. Let's break it down in simple terms. When a debtor receives a bankruptcy discharge, it is a legal order that releases them from personal liability for most debts. This includes debts owed to unsecured creditors. So, what does this mean for those creditors? Essentially, once the discharge is granted, unsecured creditors can no longer sue the debtor to collect those discharged debts. This means they lose their legal right to pursue collection actions like lawsuits, wage garnishments, or property seizures related to those debts. However, there are some exceptions to this rule. Certain types of debts are not dischargeable. For example, debts related to certain taxes, student loans, child support, and debts arising from fraud or willful misconduct can still be pursued by creditors. If an unsecured creditor holds one of these types of claims, they may still sue after the bankruptcy discharge. Now, what happens if an unsecured creditor tries to sue anyway? In such cases, the debtor can use the bankruptcy discharge as a defense. Courts typically dismiss these lawsuits because the discharge order prohibits any collection efforts on those debts. It is important to note that creditors attempting to sue on discharged debts often face unsuccessful outcomes, and this can even lead to sanctions against them. During the bankruptcy process, unsecured creditors have the opportunity to file claims to receive a share of any assets liquidated by the bankruptcy trustee. However, once the bankruptcy case is closed and the discharge is granted, the ability of creditors to collect directly from the debtor ends. For debtors, it is essential to keep documentation of their discharge order. They should be aware that any attempts to collect on discharged debts after the bankruptcy discharge are unlawful. If they find themselves being sued, they should inform the court about the bankruptcy discharge to halt the lawsuit. There are special situations to consider as well. If a creditor holds a secured claim, meaning it is backed by collateral like a car or house, they may still enforce their lien by repossessing or foreclosing on that collateral, even after the discharge. Additionally, creditors may attempt to collect from guarantors or co-signers who did not file for bankruptcy, as the discharge applies only to the debtor. In summary, unsecured creditors generally cannot sue after a bankruptcy discharge to collect discharged debts. The discharge acts as a legal shield, preventing lawsuits and collection efforts on those debts. However, creditors can still pursue non-dischargeable debts or enforce secured claims against collateral. Understanding these rights and keeping discharge documentation is key for debtors to protect themselves from improper collection actions.